This is Ngala Budja. This is our land. Well, many years ago, before the European people arrived here, I mean, it was freedom for my people, and they roamed this area freely, and they done their gathering of food and berries and nuts, and they had plenty to eat and plenty to drink. My name is Doolann Leisha. I'm a Noongar woman.
The old dreaming story that started at the base of Kings Park and through that region, actually the trail goes directly past and just behind the Supreme Court Gardens and the old courthouse. So in a way that was a very not necessarily religious area, but it was the area that you sort of paid the utmost respect, and you never in any way wanted to damage or cause strife. My name is Sealin Garlett, and I'm a Noongar man from this area, and I just feel very honoured to be linked to this time of story and a time of acknowledging this very special place.
So Kings Park had three names. It had Carl Dookaning making fires and Jinning and Bo seeing the fires from a long way. And they also called it Karakumba, or Kumba Cart, meant a big head.
Jinning and Bo, Kara Murna, Jinning and Bo, Kara Kumba, Jinning and Bo, Jinning and Bo, Jinning and Bo. Jinning and Bo, Nyunga Boja, Jinning and Bo, Ngala Boja, Jinning and Bo, Birla Boja, Jinning and Bo, Jinning and Bo, Jinning and Bo.
Perth is situated on a ridge between the Swan River and the swamps where the present railway line is, and it was a favourite camping spot for the Muru people, who were part of the Great Noongar Confederation. Their main camp was on Mount Eliza, and when Captain Stirling arrived, he saw Mount Eliza as a protection against possible naval bombardment, so he wanted to situate his town on the side of the river where the Muru had been accustomed to hunt. I am Professor Geoffrey Bolton, historian.
This place where we are today is particularly important to Noongar people. It was a meeting place, and it was a place where many Noongar groups would come to share stories, to sing, to dance, to participate in sporting activities. After the events, jump in the river, cleanse, and go back to the meeting place to share with the rest of the community. I'm Irene Stainton. I'm a respected Noongar elder.
The past and the present exist together, and we know that. That's very strong among our people, because our people still honour the laws. They still worship the laws. Yeah, the law, and it was the dream time of creation that our people came from. And it continued into the present. It's still with us today.
So really the law wasn't added on to us being Aboriginal. Our ways and our laws filtered and was able to saturate the core of our lives.
The old courthouse was constructed on the south side of St George's Terrace, and this was a departure from the original plan, which had been to leave the whole south side of the terrace overlooking the river unbuilt upon. But the demand was too great. Government House was eventually to be founded there. The courthouse had to be close to Government House. It was across the road from St George's Anglican Cathedral, and it was on the main pedestrian thoroughfare.
The courthouse was built in 1836 at a cost of £698.
The foundations are to be large limestone blocks embedded in lime mortar. The walls will be 14 inches thick without the plastering. All openings shall be turned with flat arches. The roof will be of timber shingles on top of pine.
Captain Stirling commissioned Henry Reveley, the colonial civil engineer, to prepare plans and specifications for a courthouse. I'm Geraldine Byrne. I'm a historian.
This courthouse had more than a merely functional purpose. To the inhabitants of Western Australia, only a few thousand of them, it was a sign that the security and the authority of Britain had not left them behind.
This building was used as a courthouse between 1837 and 1856. It was also used for musical evenings, including a concert given by the founder of New Norcia, John Salvato, in 1846. In 1849, it was the venue for a meeting where it was decided the colony would have convict labour.
All in favour? Aye.
In 1863, following repairs and alterations to the building, it was used once again for the Supreme Court.
All rise.
The early colonists had some very serious problems administering the law in Western Australia. I'm Wayne Martin. I'm the 13th Chief Justice of Western Australia. Before this building was built and occupied in 1837, there was no building readily available to administer the law. In the early days of the colony, the legal issues they confronted were fairly basic. They involved criminal law, including drunkenness, assaults arising from drunkenness, and stealing. On the civil side of the court's work, there were issues relating to unpaid debts and employment issues.
Michiguru was a significant Noongar leader. His case never made it to court. My name is Sarah Toohey. I've been involved with the old courthouse as a curator. Michiguru and his son Yagan and another man were involved in a reprisal killing. Michiguru was pronounced an outlaw and a reward of £20 was offered for his capture, dead or alive. Michiguru was apprehended in 1833 and executed without a formal trial. He was tied to the door of the Perth jail and shot.
This was a military form of punishment and showed the need for the rapid establishment of civil legal institutions, as well as the need for a courthouse in which the proceedings could take place.
The trial of Jane Green in 1840 is remarkable for two reasons. It was the first case in the Swan River colony where the defending counsel wore a gown and a wig, and it was the first time a woman was accused of murder. Jane Green was an 18-year-old orphan who was brought to Western Australia in 1839 and worked as a servant for Captain and Mrs. Whitfield. She became pregnant to employer and gave birth to a child who was found dead. A newly arrived lawyer, Richard Nash, defended her. The court was sympathetic and Jane was acquitted but sentenced to 2 years' imprisonment for concealing a birth.
The first legal execution in Western Australia was a double execution of two Aboriginal men, Doolann and Barrabong, in 1840, for the murder of Sarah Cook and her baby on a farm near York. Barrabong told an interpreter it was payback for the killing of an Aboriginal woman by white people. After they were sentenced to death, Doolann and Barrabong were taken by cart to the scene of the crime to be hanged.
John Gavin was the first European to be executed in Western Australia, and sadly he was only 15 years old at the time he was hanged. Gavin had been born in 1829 in England, the same year the colony was founded, and he was transported to Western Australia in 1844 as a result of trouble that he'd been into in England. He didn't have any parents. When he arrived in the state, he was settled with a family called the Pollard family in the Murray district of the state. But unfortunately he got into trouble shortly after arriving and ended up murdering young George Pollard, who was 18 years of age at the time. Gavin confessed to the murder, so the trial would have been a fairly perfunctory affair. And 3 days after he was tried, Gavin was taken to the Roundhouse in Fremantle and hanged until dead.
Archibald Bert was the first Chief Justice appointed to the new Supreme Court in 1861. His background was in the West Indies, which had until recently been slave colonies, so he adapted quite readily to a convict colony such as Western Australia. He was very even-handed. He wanted to see equal justice to Aboriginal and white people, and incurred great controversy in 1872 by sentencing a prominent young pastoralist to 5 years imprisonment for killing an Aboriginal. Protests to London had the sentence reduced to 1 year. Bert was consoled by being made a knight.
In 1829, the English settlers brought with them to Western Australia a culture and legal system that was very different to the culture and legal system of the original inhabitants. This resulted in tensions between the two communities that were worked out through the court process. Because the European settlers were the dominant group, it was their laws that determined the outcome of those tensions, sometimes to the great disadvantage of the original inhabitants of the colony.
At settlement, there were all of these protocols and community laws, if you like, for Aboriginal people. And there was the concept of shared. Everything was shared. The food sources on the land, water supplies were all shared. So when settlement occurred and the new settlers started putting up fences and bringing in sheep for our people were just a food source. So where Aboriginal people used to take kangaroos, now they took sheep because they were roaming the land. Many of the offences that might have taken place in terms of European law would have been stealing. Aboriginal people wouldn't have had that concept of stealing. They were taking what the land was providing.
One of the problems arising from the intersection of Aboriginal law and European law was in the area of the law relating to evidence. Under English law, evidence could only be given by a person on oath, and to give an oath, one had to believe in God.
I swear by Almighty God that I will speak the truth, the whole truth, and nothing but the truth.
The Aboriginal inhabitants, of course, did not believe in a God that was recognised by the Europeans, so they couldn't give evidence in proceedings involving them. This was remedied in 1841 when an act which was passed which enabled the court to receive information from Aboriginal people without requiring them to take an oath.
Back in 1842, the case of an Aboriginal man called Weewa focused on whether British law applied to conflicts between Aboriginal people. Weewa's lawyer argued that Weewa was following Aboriginal law. Even so, the argument was rejected in court and Weewa was found guilty of murder in the old courthouse. His death sentence was reduced to life imprisonment.
This precinct has been the centre for the administration of justice in Western Australia since the foundation of the colony in 1829. Prior to 1837, courts were held in makeshift buildings near this site. After this building was opened in 1837, it was the dominant place in which courts were administered in the early years of the colony. Since 1903, the major building next door, the Supreme Court building, has been at the very centre for the administration of justice in the state.
I'd encourage all visitors as you wander around and take in this magnificent building and think about what goes on in terms of a legal process and legal systems in these old buildings. But I strongly encourage people to think back about how important it was culturally, how important a meeting place this was for the traditional owners, the Noongar people.
When you're in this building and looking around, try and imagine the sort of things that would have happened here from 1837 onwards, when very important trials were conducted, trials in which people were at risk of losing their life or all of their property or members of their family.
I don't like any of the buildings, the old buildings, because I feel that it wasn't any use to my people or wasn't any good for them, because in that time my people wasn't treated as human beings. They were treated like the fauna, so they didn't even treat them as people. So those old buildings, they don't mean anything to me.
If you're in this place today, you are surrounded by a very old and an ageless time. If you're in this place today, you walk alongside some very old people. And in this place that you share and that's a part of who you are today is an ageless time.